think there are two parts to the bill. The first obviously deals with the maximum sentences for incense, and the second with the introduction of new mandatory minimum sentences for repeat sexual offenders. And I want to deal with the two parts really in reverse order. I think firstly, in terms of the new mandatory minimum sentencing, I want to start by saying that I absolutely understand the motivation behind the proposal. Repeat sexual offenders have a huge impact, clearly, both on their previous victims and obviously on the people they go on to offend against. They are some of society's worst offences, and we obviously all want a regime in place which makes it less likely that someone having committed one offence would ever go on to commit another. And in that context, I have to say the bill's sentencing proposals to me run along a bizarrely complicated formula which makes no sense to me, because basically what the bill is calling for is where somebody was convicted on indictment of an offence specified in the schedule, the first offence, and was sentenced to imprisonment for at least 5 years and is subsequently convicted of another scheduled offence committed within 10 years of the first sentence, the conviction, then a presumptive minimum sentence applies in relation to the second offence. Now, the sentence for the second offence has to be at least 3/4 of the maximum sentence which can be imposed for the second offence. If the maximum term for the second offence is life imprisonment, the minimum sentence should be at least 10 years, and any suspended portions of a sentence don't apply. So, in other words, if someone was sentenced to 7 years with 3 years suspended for an offence and then goes on to commit another offence, then they won't fall under this bill's ambit because they only served 4 years of their sentence. Complicated, can't get your head around it. It seems to me to be completely arbitrary, to be honest. In any case, I have to say that the proposal in the bill to introduce mandatory minimum sentences won't achieve the goal of making offending less likely. In general, years of evidence show us that mandatory minimum sentences for any crime are actually not effective deterrents. The fact is reflected in the findings of the 2013 Law Reform Commission report on mandatory sentencing and the 2014 Strategic Review of Penal Policy. Both made clear recommendations that no new mandatory sentencing schemes should be introduced. The Strategic Review of Penal Policy in particular was a cross-agency report which included victims' representatives groups alongside agencies tasked with crime prevention and the IPRT. And while deterrence might be an appealing concept in theory, the reality is, and the empirical evidence shows us, that there is no justification for that in reality. In actual fact, there is evidence that sanctions in general maybe provide some deterrent, but no evidence to suggest that a more severe penalty is a greater deterrent than a less severe penalty. So while mandatory minimums, I suppose, have a feel-good factor to them in that they give politicians the opportunity to vent their horror at particularly shocking crimes and give the appearance of taking action, the fact is that they don't deter criminals in general. And in particular, given that the recidivism rates in terms of sexual offences are amongst some of the lower ones, I'm a bit at loss to think why we would think that this legislation would act as any deterrent to the particularly determined and particularly disturbed individuals who do buck the trend and go on to become repeat sexual offenders. On top of that, we have the point that Sinn Féin did cut a deal with the government during the Judicial Appointments Bill and looking for sentencing guidelines linked to the new Judicial Council's bill. In fact, in fairness to the judiciary, they've been crying out for that for years, particularly for tricky cases. And to me, to introduce a new regime while that's pending is completely wrong. We should also point out that the Minister is waiting for a review of presumptive minimum sentencing, which was commissioned by his department, due to be published in July. So why aren't we waiting for the outcome of that before we're rushing in with this piece of legislation? To me, it doesn't make any sense, because the reality is that mandatory minimums are knee-jerk responses to media hype. Sentencing guidelines, on the other hand, are carefully considered, data-based and evidence-driven, and they are far more effective than, and useful, and I think the judiciary themselves would feel that. I think as well, when you look at it, that the bill, while recommending a presumptive minimum, allows judicial discretion in applying the minimum sentences, so ultimately it's bringing it back to the judges anyway. So what's the point in having this legislation at all? It defeats its own purpose and its own stated objectives. Why not expedite the Judicial Council bill, which we have been promised since the start of this government, and create proper sentencing guidelines? To me, if this is politics, well, it's pretty poor politics. And it's selling people short. If we're saying the goal of this bill is to say right the wrongs of the past, whereby obviously, and other deputies have said it, we've seen some absolutely shocking sentences handed down for some of the most appalling sexual crimes. But, if that's cases of, say, where sentences have been totally suspended, or where the offender has been invited to make a financial contribution to the woman he raped or whatever, appalling sentencing, we know that. But the fact that suspended sentences aren't counted in this legislation in calculating the minimum for the second offence, then you're not going to fix that problem by this legislation. It falls short on that count as well. So to me, it's completely wrong that we will be introducing anything like this at the present juncture. The bill's other provision around incest, well, I see no problem with aligning the maximum sentence that can be given to men or women. I've no problem with the reduction in the maximum sentences, given that the bill is relation to, if you like, consenting adults, while obviously other aspects of our criminal justice legislation deal with abusive or coercive incest. But I think that's something that we should be looking at in terms of this legislation, because the issue of sexual abuse, and particularly child sexual abuse, is something that sadly overwhelmingly takes place within families and within extended families, and it's something that's incredibly in the focus at the present time. I mean, HICWA's recent report on how TUSLA manages allegations of child sexual abuse was a scathing indictment of the failures on the system and should worry us all intently. It incredibly worries me, and what worries me even more than that is the amount of people who have been in contact with us, who have seen children go through that system and have seen the system fail at multiple different points of the process. And I'll give you an example that captures not just the problems that exist in terms of how allegations of child sexual abuse are dealt with, but also how those problems radiate out and compound the really serious problems that exist in our family law system. So let's say a child makes a disclosure to her mother that her father is sexually abusing her. The mother, horrified, reports it to TUSLA. TUSLA does a preliminary assessment and decides that the allegation is credible enough for a full assessment to be done. So the child goes in for an interview, if she's lucky, by a specialist unit. There are a couple of them around the country, but if she doesn't have a specialist unit nearby, then she's going to be assessed by social workers whose training and skill in this type of forensic interview techniques needed for this delicate work may not always be present. So the full assessment might be a couple of 15-minute interviews. That's done, and there's only 2 findings available. The allegation is either founded or it's unfounded. And unlike, for example, criminal law, where there can be a finding of insufficient evidence, that's not provided for here. Once a decision has been made that an allegation is unfounded, that's it. Case closed, file on the shelf, dust gathered. So prior to the child's interview, there was no risk assessment, there was no home visit, there was no investigation. Once an allegation is unfounded, there's no follow-up whatsoever. That's it, game over. And your colleague minister, the Minister for Children, told me recently about this blunt tool that TUSLA are civil authorities making findings on the balance of probabilities. She went on to say, this may differ from the burden of proof for criminal prosecution required by investigations by An Garda Síochána, but that's just the problem. TUSLA are making findings on the balance of probabilities, but if they get it wrong, and determine that an allegation is unfounded, then the child is condemned to continue to being abused. I think it particularly applies in cases where the child lives with a parent who's carrying out the abuse on them. Surely we should be looking at legislation at the moment for a middle ground between founded and unfounded. Call it insufficient evidence or whatever, but something that puts in place a risk assessment that really protects children and having meaningful engagement in that regard. If you look at it and we go back to our, I suppose, hypothetical child, the allegation is found to be unfounded. Tusla closes the case. The mother can't believe it and is even more horrified when her daughter goes on to make further disclosures of sexual abuse by the father. The relationship between the parents has broken down in the meantime and custody proceedings have started. Every time her daughter discloses abuse by the father, the mother reports it. But because it's been deemed to be unfounded, the mother soon has social workers sitting beside her, telling her she's the one who's abusing her daughter, by emotionally abusing her, by coaching her in these. The child keeps coming back and saying terrible things are happening. Things get worse because the mother won't shut up. Now she's accused of coaching. Custody proceedings are in full swing. The court then orders a Section 47. Now, I've raised these issues before with the Minister. A Section 47 report are complied by either a psychotherapist, a psychologist or a psychiatrist. And the idea is there's supposed to be a guidance to the judge. In practice, judges weigh very heavily on these. They're not supposed to completely, but they rely on them very severely. But in some instances, in the instance I gave, our hypothetical one, the person doing the Section 47 is a psychotherapist. It's an unregulated profession. They can basically say what they like in that determines the fate of that child. And courts have ordered the child to remain with the abuser, to go into the full custody in that case. This is an absolutely crazy system. And if we want to deal with abuse and sexual abuse within families, then we absolutely have to be paying attention to this massive deficit in our system, because psychotherapists theoretically can do what they like during the interview process. As I said, we're talking about interviewing children, vulnerable children, who have nowhere that anybody can turn to complain about. So if the child in that situation is in the middle of a custody battle, the psychotherapist doing the Section 47 has seen the report from Tusla with the assessment on the original allegation as unfounded, has been told that the mother won't let it go, that she's the one doing the abuse, and then suddenly the process unwinds. The mother has nowhere to go or complain about that because, hey-ho, family court is in camera. And what that means is that, in essence, it's a criminal offence if you disclose to anybody not involved in those hearings what happened in that court case. So there is nowhere for that to go. It is almost like a licence to facilitate paedophilia in this state. And the sad thing about it is that this hypothetical instance isn't hypothetical at all. There are people in Ireland today who are in that situation because of the shortcomings in our legal system. I think that this is going to be the new scandal of our age, and while fully ensuring and hoping that the motivation of people here is to help people who are the victims of sexual abuse, if we don't address this time bomb of this in-camera rule and this appalling way of dealing with child sexual abuse in our state, then we have a new modern horror scene on our hands, the likes of which makes abuse that happened to children in our state in the past pale into insignificance. And I really think we should be using opportunities of legislation like this to deal with these appalling deficits, rather than dealing with, while it's nice to equalise sort of consensual incest, it's not really at the races in terms of the appalling child sexual abuse that goes on and is sadly going on and not dealt with in this state.